So are you wondering how to create a legally valid will in the state of Florida? Well, in today's video, I'm going to answer that question. So have you ever thought about what would happen to your belongings and assets if something were to ever happen to you? Well, making a will is really important. Unfortunately, a lot of people put it off, either because they think it's too complicated or that it's something only the super wealthy need to do. And actually, that's just not true. In fact, creating a valid will in Florida protects your loved ones and makes sure your final wishes are carried out properly after you're gone. But don't worry, I'm going to break down exactly what you need to do in simple terms. Hi, my name is Chuck Roulet. I'm an estate planning attorney licensed to practice law in both Florida and Minnesota. And with over 25 years of experience, I've seen firsthand how not having a proper will can cause a lot of headaches and legal issues for families. That's why in this video, I'm going to share the requirements for creating a legally valid will in Florida. Having a will gives you peace of mind knowing your loved ones will be taken care of exactly how you want it rather than how the state wants. Now, first, let's go over who can actually make a will in Florida. It's pretty straightforward. Any mentally sound person who is 18 years or older can create one. In fact, even 16 or 17-year-olds are allowed to if they've been legally emancipated minors. Now, the big question, what makes a will valid in our state? Well, Florida has specific rules that the document must follow to be legally binding. First, it needs to be in writing, and you must sign at the very end of it, okay? Now, if you can't sign for yourself for some reason, no problem. Someone else can sign it for you, but they have to do it while you're present, and you have to directly instruct them to sign your name. So again, it has to be in writing. You have to sign it. Next, witnesses. When you sign your will, either yourself or acknowledging your prior signature, it has to be in front of at least 2 witnesses who are physically present. Now, those 2 witnesses then also have to sign the will document while you and the other witness are both there. So again, you have to sign it in the presence of 2 witnesses, and the witnesses have to sign it in the presence of each other. So in summary, your written signature, 2 witness signatures, all done together. Now, following those steps will make your will properly executed under Florida law. Now, you may be wondering, what about out-of-state wills or military wills? No worries. Florida accepts any will that was valid where it was originally created, even from another country. And of course, any military will follow federal requirements is good to go too. Now, that being said, if you have a will or other estate planning documents from another state, there are a couple of reasons why you may want to update them to Florida law. First, your family is less likely to have issues managing your affairs here in Florida. Second, having your documents updated to Florida law is a factor in your favor if you move to Florida and you're ever challenged by your old state as to whether or not you should still be a resident of that state for tax purposes. Finally, if you have a trust, you'll need to update it to conform to Florida's laws for the execution of trusts and to maintain your Florida homestead for property you put in it. Now, one really useful thing I always recommend is self-proving your will. Now, this is where you, the witnesses, and a notary public all sign affidavits together verifying the will's validity. By self-proving it, your witnesses won't need to testify in court later, which can save time and money. So those are the must-know basics for getting a valid, legally binding will in place for Florida. But again, I can't stress enough how important it is to work with an experienced estate planning attorney on this. We know all the little nuances to look out for based on your personal situation. And in our firm, we take a customized approach working one-on-one to ensure your will covers everything, and strategies like trusts are included if they could benefit you. Don't leave your legacy to chance. Set up a consult with us and we can get started to help you protect what matters most to you. So again, you can call, email, or request an appointment right on our website at rouletlaw.com. We have a link in the description below if you would like more information. And if you would like some additional information, I'm actually hosting a free online masterclass. And again, you can sign up by clicking, we have a link below. And in this class, I'm actually going to reveal some of the insider strategies for your will, trust, powers of attorney, and healthcare documents that can help your family avoid probate, save on taxes, and make it as easy and inexpensive as possible if something were to happen to you. And if you haven't already, make sure you hit the like, subscribe, and bell notifications, and you'll be alerted when I upload additional videos. Finally, if you have a question, post it in the comments below, and I may answer it in an upcoming video. Having a rock-solid will in place will give you and your family tremendous peace of mind for years to come. I hope you found this video helpful. I look forward to seeing you in the next one. Be well.